My name is Andrea Lynch. I'm a Principal Associate specialising in construction and engineering risks within our insurance practice area at Mills and Reeve. I'm joined this morning by my colleagues Ben Hardiman and Andrew McConnell, who also both specialise in construction and engineering risks. Morning both.
Morning.
In this session, we will hone in specifically on common methods of dispute resolution in the context of a construction professional negligence claim setting. We will start with the less utilised methods and work up to the universally popular mediation. During the course of the session, we will be running some polls so we can practically apply some of the information we will discuss in today's session. This session is being recorded, and whilst you can see us, we cannot see you. And also all of the polls are anonymous. Ben, I think you're going to kick us off this morning by talking to us about one of the less utilised forms of dispute resolution in a construction setting, which is expert determination. Can you tell us what exactly that is?
Yeah, thanks, Andrea. Hello, everyone. As you rightly say, it is probably one of the more uncommon forms of dispute resolution in a construction context, but it's something we have seen adopted, and a few of the people on the poll had experienced it. So it's something we wanted to mention today. In brief, expert determination is a binding dispute resolution process. It's established by the terms of the contract, which the parties enter into for the purposes of the project, and it tends to be used in disputes where there's a scientific, specialist or technical problem.
Great. Well, obviously, every construction dispute will involve specialist and technical issues, so this sounds like a perfect forum. Are there any downsides to expert determination?
Yeah, I think there are. The problem is that, as I said earlier, this is a contractual mechanism. So the scope of the procedure, potentially even the identity of the expert to be appointed, and that person's remit are all driven entirely by the provisions of the contract. So the main downside is that when the parties enter into the contract, they don't necessarily know the scope of the potential dispute, which may not arise for several years. And that can mean that an expert determination process is entirely unsuited to the dispute that later arises, but by the nature of the contract, they're bound into it. Secondly, and as I put on the screen, this is perhaps a bigger issue from a construction perspective, which is it is less suited for resolving claims which involve factual disputes and which are going to involve some review of documentary or witness evidence. It's also not good where there are particularly complicated legal issues involved, because more often than not, by their very nature, an expert is an expert and not legally qualified, so may well not be able to provide the input into those parts of the dispute.
Thanks, Ben. And what would you say are the main benefits of using expert determination?
Yeah, there undoubtedly are some. I shouldn't cast aspersions completely. It's less formal than litigation or arbitration, so it's generally quicker, it's generally more cost effective. It's also a confidential process, so it offers the parties a way out of a dispute whilst giving the chance of preserving an existing relationship. Also, the benefit it gives is having an independent party with specialist technical knowledge and perhaps familiarity with the problem that's arisen that can give a decision which enables the parties to walk away knowing that the outcome can at least be objectively justified because someone who knows the issue has made a decision.
So just talking about a decision, a key question is expert determination binding?
Classic lawyer's answer for you on this one, Andrea. The answer is not completely straightforward. I think the answer is ultimately yes. The reason for a caveat is there's very little established case law relating to expert determination because it's far less used than the likes of arbitration and adjudication. But where issues have come before the courts, generally judges have taken the view that an expert's decision is binding and shouldn't be interfered with, because someone with appropriate knowledge and expertise who's been appointed by agreement of the parties has reached a reasoned view. So in reality, the ability to challenge is very limited. The right to appeal is virtually non-existent. If you don't like the outcome, the reality is you're pretty much stuck with it.
And finally, Ben, just when you've got the determiner's decision, how then do you enforce it?
Well, it can't be enforced without court action. So the mechanism is that the decision becomes part of the contract. So if there is a failure to comply with that decision, that amounts to a breach of contract. That means you have to go through the courts to enforce it.
Great, thanks, Ben. Turning now to the second method of dispute resolution we're going to talk about this morning, which is arbitration. Again, this is one of the less common forms of dispute resolution that is utilised in a construction setting. Andrew, can you explain to our attendees what exactly arbitration is?
Thanks, Andrea, and good morning, everyone. So yeah, arbitration is obviously an alternative to litigation, and it's based on the parties' agreement. So all parties to the dispute must agree to submit it to arbitration. And like a judgment, the decision of the tribunal is a final and binding one.
And what are the usual drivers for parties when choosing arbitration?
So you'll see from the slide, I've sort of broken it down into four main objectives, if you will. So the first one is privacy and confidentiality. So unlike court proceedings, the parties to an arbitration are bound by duties of confidentiality. The second is the flexibility of procedure. So the parties have the power to agree to a particular procedure that suits their needs for the case in question. The next point is obviously the choice of tribunal. So the parties can choose a tribunal with relevant expertise, which is obviously quite important when we're looking at quite specialised and technical construction disputes that we advise on as a team. And finally, the award is final and binding, as I alluded to earlier, and there are very, very limited grounds on which to appeal the decision of the arbitration tribunal.
Thanks, Andrew. Are there any procedural points that people should consider before commencing an adjudication?
Yeah, there certainly are, and I think the parties always need to consider applicable time limits. So the parties, or the same statutory time limits rather, apply to arbitration proceedings as those for civil court proceedings. I won't go into those now, that's probably an entire seminar on its own, but the parties should be aware of limitation. Alternatively, if there's an arbitration agreement, it might contain a clause that requires arbitration proceedings to be initiated by a certain time. The parties should also confirm the necessary steps in order to commence an arbitration, which may include things like making a claim, nominating a specific arbitrator, or indeed just notifying the other side of your intention to arbitrate.
Thanks, Andrew. I mean, out of interest, why do you think it's one of the less commonly utilised forms of dispute resolution in a construction setting?
Well, there are probably several reasons, Andrea, but I think it's primarily because arbitration is final and binding, as I've mentioned several times now, which leaves very little room for negotiation between the parties. It can prove costly in terms of costs for lawyers and the arbitrator themselves. And there are other forms of ADR available, which are potentially more cost effective and quicker forms of resolution. And we'll obviously come on to those later today.
Great, thanks, Andrew. Turning now to the next form of dispute resolution, which is adjudication. I know that a number of our attendees have expressed they've experienced this previously. So we're just going to run a quick poll before I turn over to Ben. So typically, how long is an adjudication procedure? So we have four answers there. So 1, no time limits, 2, 28 days, 3, 14 days, or 3 months. Quite a mixed bag. Most of you are going for 28 days, but sorry, these are changing quite a bit. 11% think 3 months, 18% think no time limits. Ben, I think you'll come on to this to explain that in principle, the idea for an adjudication procedure is that it will start and finish within 28 days. This seems like an incredibly short timescale. So I'm wondering, is adjudication even appropriate for a construction professional negligence dispute, which at the heart stems from a breach of a professional's duties?
Yeah, thanks, Andrea. You're right. The timescale is incredibly short. The answer is start to finish, absent any agreement to the contrary, within 28 days. And I think one might question, with some legitimacy, how an adjudicator can properly assess the sorts of things which are necessary to resolve many professional negligence disputes in a construction sphere. More often than not, adjudication is used to address questions of delay, disruption, payment disputes within the scope of an ongoing project. But the reality is that this is a statutory mechanism. It was created by the Housing Grants Construction Regeneration Act back in '96, and it gives the party a right to refer a dispute arising under a construction contract. Now, the Act defines a construction contract fairly broadly. It includes services ranging from architecture to design and surveying work, through to the building and engineering aspects of a project. And since, subject to the usual limitation rules that Andrew referred back to, a claimant can serve, or a referring party can serve their notice of an intention to adjudicate at any time, and that wording has been found to mean that a dispute can be referred after practical completion. That's obviously relevant to PI disputes, given that many will arise from latent defects which are just not apparent prior to practical completion and may not arise for several years. So there's no express prohibition on adjudication being used for PI related disputes. Parties can't contract out of the Act. So if there's a dispute, it is an option for the claiming party.
Great, thanks, Ben. So if you can just talk us through what the exact procedure is for an adjudication, that would be helpful.
Yeah, as I said, dispute can be commenced at any time. So bearing in mind the tight timetable, which I'll talk to you about now, a referring party will usually do all that it can to ensure that its case is in order before it takes steps to commence the process. But what they have to do is to serve a notice of adjudication, and they apply to a nominating body to appoint the adjudicator, and that appointment must occur within 7 days. The referring party then serves a referral notice, which is the equivalent of particulars of claim, within 7 days. And the responding party has 7 days to serve a response. So it's possible to agree to extend that, but it's ultimately at the discretion of the adjudicator to do so. The referring party will often have permission to serve a reply within 3 days. Now, these are the bits that create the issues. Unlike litigation, there's no disclosure exercise. There's no exchange of witness evidence. There's no exchange of expert evidence. Details can be submitted with the statements of case, but bearing in mind the timescales, and bearing in mind this may come completely out of the blue, you may well really struggle to pull that together. The adjudicator can call the parties to attend a meeting, but doesn't have to, so you may well not have any oral submissions. And ultimately, unless an extension is agreed by both parties, the adjudicator has got 28 days from service of the referral notice to reach the decision. Thanks.
So clearly it's a really speedy process. So the key question is, what if you don't like the outcome?
Yeah, you're almost stuck with it. An adjudicator's award is known as interim binding. That means it's binding unless it's challenged in subsequent proceedings, so whether via courts or arbitration. Adjudication decisions have to be enforced by the Technology and Construction Court, but since the court upholds the vast majority of adjudication decisions, challenges are rare, and so the majority are just simply accepted.
And what are the benefits of using adjudication, Ben?
Well, it comes back to time and cost ultimately. The reason adjudication was introduced back in '96 was to create a method of dispute resolution which would expeditiously and relatively inexpensively deal with disputes. Now, that's the wording of the people who prepared this. So whilst there are undoubtedly risks for anyone entering into this process, it's often been referred to as shotgun justice because it's such a high level process, because an adjudicator can't really consider the detail quite as much as a court would. But the converse is that it is relatively quick and cheap when you compare it to legal proceedings, which may take a couple of years to get from start to finish, and undoubtedly very significant costs. And just on the question of costs, this is another area that can cause some tension. Unless agreed otherwise in writing as part of the adjudication process, costs don't follow the event as they normally do in litigation. So the successful party doesn't recover their costs. Where an award might be made is that the parties are jointly and severally liable for the adjudicator's reasonable costs and expenses, but the adjudicator may well apportion the amount between the parties as he or she decides.
Great. And so just before we move on from adjudication this morning, I think it'd probably be helpful for our attendees, particularly in light of such tight timescales. Do you have any practical advice you would give?
Yeah, it goes back to time being of the essence. Read your policy. The policy of insurance, your PI policy, most normally include a specific notification provision for adjudication. So that's separate to the normal notification provisions. The majority require notification within 2 or 3 working days. Now that is obviously very tight, but if you don't get things moving quickly, you're not going to be able to respond in time. So that's relevant both for professionals and contractors and the like on the call. It's also relevant for brokers who receive these notifications. You really need to get them over to insurers very quickly.
Great, thanks for that, Ben. That was really helpful. Andrew, we're now going to turn to the final method of dispute resolution that we're going to look at today, which is the universally popular mediation.
Yeah, thanks, Andrea. So I know many people will be more than familiar with mediation, but I just wanted to recap on some of the basics, essentially. So mediation is obviously a flexible, voluntary and confidential form of ADR, and it involves a neutral third party, being the mediator, assisting the parties towards a negotiated settlement. And crucially, for a mediation, the parties retain control over A, whether or not to settle, and B, if so, on what terms they want to settle. And unlike a judge or arbitrator, the mediator will not decide the case on its merits, but will work to facilitate an agreement between the parties. And usually the parties to a mediation are required to treat all discussions and documents as entirely confidential and without prejudice.
And what are the common purposes of using a mediation?
I think there's quite a few, but and it's probably a mixture of the following, really. But there's narrowing the issues in dispute, which is obviously important, avoiding costly litigation, and then resolving the dispute itself, if possible. That's obviously the ultimate goal. And it's important to note, and perhaps it's why mediation is so popular, is because it's suitable for all kinds of disputes, whether it be small claims of a low value or high value, quite complex and technical construction disputes.
And what would you say are the main benefits of using mediation, comparing it to the other forms of dispute resolution that could be used?
Well, I think there are plenty. So business relationships can be preserved. That's obviously important given my confidentiality point from earlier. And the parties have also got complete choice over the selection of a mediator. Obviously isn't the case when it comes to a trial judge as much as we'd like it to be. So you can pick an arbitrator with a suitable approach and suitable expertise. A mediator. Getting them confused now. But obviously, often mediation avoids expensive litigation, although there are obviously legal costs associated with preparing for a mediation, and you've got those of the mediator themselves. Mediation can provide a speedier resolution, so we're talking a number of weeks to really get a mediation sort of arranged, which obviously isn't the case with court proceedings. Can take much longer. Mediation has a high success rate, and I think quite importantly, even if a mediation doesn't resolve the dispute and you don't end up with a settlement, it's often quite a helpful process for the parties just to get together, listen to each other's positions and perspectives. That in itself can form a very beneficial process for everyone involved.
Yeah, great. Thanks, Andrew. I think we've got another quick poll, which should hopefully be on your screen now. So for those of you who've attended mediations, the question we've got is, which of the below factors would you consider most essential to productivity of a mediation? So the right mediator for the case, preparation of parties and management of settlement expectations, a sensible starting point in terms of opening offers, the fact that it's binding, a strong mediation position statement and one that's exchanged in advance. A large number of people are voting here, quite a mixed bag, which is a lot of you think the choice of mediator is a priority, preparation as well. Andrew, 20% of our attendees this morning are suggesting that one of the factors that's most essential is the fact that mediation is binding. Do you want to talk to us a bit about that?
Yeah, I mean, we threw that in as a bit of a red herring because mediation is obviously not binding, as I mentioned earlier. So that's something to bear in mind when going along to a mediation. There's no obligation on the parties to come out of it with a settlement. And I think it's quite interesting as well. The poll revealed that choice of mediator is an important factor, and I think that's true. And I think panel solicitors, we'd always have a selection of recommended mediators for a particular dispute.
Yeah, definitely. Just finally then, Andrew, again, a key question is, do you have any, from your experience, do you have any practical tips in terms of preparation and attending a mediation that makes it more successful?
Yeah, as we've alluded to, the right mediation for the right case, the right mediator for the right case. So someone who might be a straight talker could be sort of sensible and appropriate for a particular case. On the flip side, you might need somebody who does a bit more hand-holding, for example, if a claimant or other party isn't legally represented. So this obviously depends on the facts of the case. You obviously need to think about who's going to attend. So are you going to have lawyers in attendance? That's quite common, of course. Directors and officers of your client, claims handlers for insurers who can be very important on the day in terms of negotiations and settlement authority, and insurance brokers to help the insured through the process. Another factor is whether it will be online or in person. I think we'll probably see a bit more of a return to sort of in-person mediations after the pandemic, but in recent months, we've obviously gained quite a lot of experience in conducting mediations via Zoom, and they have proved quite effective as time has gone by. And the mediator can obviously utilise breakout rooms to maintain confidentiality and things like that. So they can be quite appropriate for the right case if you do them virtually. Another thing to consider is whether there'll be opening statements in a sort of preliminary session. They can provide a really good opportunity to get things out in the open and confirm that the parties are attending in good faith. But you don't want to use them as an opportunity to just antagonise each other and rehearse previous arguments that you've already exchanged in correspondence. So it's something to think about. Another factor is settlement authority. Do you have the requisite settlement authority before the mediation? And by that, I mean from any insurer clients and indeed from the insured client, but also, do you have somebody there authorised to sign the settlement agreement once it's finalised? That can be an important factor on the day. And just a final tip is sort of having a hard copy draft settlement agreement ready to go on the day, because there's nothing more frustrating than reaching a settlement but then having to spend quite a few stressful hours at the end of a long day scrambling around trying to get a settlement agreement together. So that's something to be avoided with a bit of preparation, I suppose.
Yeah, definitely, Andrew, definitely. Thanks, Andrew, and thanks also to Ben. In today's session, we've not touched on the other main method of dispute resolution, which is, of course, court proceedings. We will cover those in later breaking ground sessions. But it's important to note that the main reason that these alternative forms of dispute resolution have actually been created is to try and avoid the lengthy and expensive court proceedings. Costs and speed are a key driver in these alternative methods of dispute resolution, but parties should be careful to seek to match the resolution process to the dispute itself, and also ensure that any contracts that you're entering in a construction setting do contain appropriate dispute resolution clauses. Picking the right process may be key to the success of achieving resolution of a dispute. That's all we've got time for today. Thank you so much for joining us this morning. The next Breaking Ground webinar series will explore the life cycle of a claim, of a typical professional negligence claim in a construction setting, from notification through to settlement. The first webinar of the new series is titled First Steps When Notice of a Claim Lands on Your Desk, and that's going to be held at 11 a.m. on the 13th of October. We do hope you can join us then, and wish you a good rest of the day.